Good day, everyone. Welcome to this episode of season 3 of the POSHpod. We are discussing today the gray areas and some nuances around the conciliation process under the POSH Act, right? So, in an earlier episode, we touched upon this briefly when discussing the amendments under the POSH Act. And one of the amendments was to do away with the conciliation provision, where you may have heard me say very vociferously that I love the amendment because I don't believe that this conciliation process as it is today is serving a true purpose because of the difference in bargaining power between the complainant and respondent very often, meaning that the conciliation is often not a truly voluntary process, right? That and it's often a coerced kind of conciliation that happens, and doing away with it may be a good thing. But till the time that the conciliation process is done away with and abolished from the POSH Act, it is here. And while it is here, the reality is there are still a number of nuances under the conciliation process that are worth discussing in terms of how to make it most efficient and make it most realistic and fair and conciliatory, right? So that's where we are today, and we'll be discussing a few of those broad heads in today's episode. You know us, but to briefly introduce ourselves, my name is Bishen Jeswant. I'm a partner in the employment law practice at Cyril Ramesh and Mangaldas. With me is Laxmi Char, co-founder Parity Consulting, and I will throw to Laxmi to take it away and tell us about the first gray area nuance under this conciliation process that she'd like to discuss.
Yeah. So talking about the settlement agreement, and if we look at the lifestyle of the agreement, right? The first, this thing is, where does it start? How does it start? Who starts it? And the Act is very clear. It says it is the aggrieved woman who may choose to initiate the conciliation process, right? Unfortunately, the reality is that many women may not even be aware of this possibility. So there is, and we know it's true in our society, this fundamental hesitance that many women have after having been subject to sexual harassment, for them to raise their hands, identify themselves and say, hey, I have this issue that needs to be dealt with. Perhaps if they knew that there was a conciliation element instead of a full-scale investigation, they may have chosen to do it. But who's going to tell them? Yeah. And that's really where, again, I'm going back. When we talk about the prevention and prohibition, I think it's interesting to see how organizations are beginning to become clearer in the way that they are, focusing on the various elements of the POSH Act. We know training is mandatory. So can we provide information, and definitely that's something which is strongly suggested, provide information that is practical and relevant to the employees, right? Whether an aggrieved woman or whether a respondent. So we are beginning to see that. The other element, and this is where I'll kind of, bring you in, Bishen, is the role of the IC itself. So again, the Act is very clear in terms of almost like a checklist of what needs to be in the complaint, right? The dates, the names, the description, all of that stuff. So one of the things that we're exploring also broadly in the POSH area is, can the IC be upskilled enough to have that prelim meeting and to share with the woman what her options are? Hey, if you want to go to the police, the Act does give you the opportunity to do that. If you want to raise a complaint, have a formal investigation, yes, you have the right. And by the way, you also have a right to initiate a settlement agreement or the conciliation process. I'd love to hear from you how you are seeing this play out.
Yeah, Lakshmi, absolutely. So I don't think the IC even needs to be separately empowered to do that. I mean, I believe the IC already has the ability to do it. There's nothing which restricts them from doing it. In fact, the POSH Act says that the IC is to take steps to settle the matter through conciliation. That's how the section is worded. Though the section, like you start saying, is very clear that it's to be done at the behest of the woman, which is the complainant, right? So, yes, the IC must take steps. So I don't see an issue here with the IC bringing up the possibility of conciliation. Yes, the Act says that you must do it at the behest of the woman, but the IC can still, like you indicated, maybe give her the option of entering into a conciliation proceeding. And if she doesn't want to do it, then the IC doesn't have a right to, enforce a conciliation proceeding. But they certainly have the option to bring it up and for her to accept or refuse. There may even be cases where the respondent brings it up, right? And you can then ask the question, what is the IC's obligation then? Because the act doesn't talk about what happens when a respondent brings up conciliation. I would say that even in that situation, the IC can accept his request and take it to the complainant and say, see, he has asked for conciliation. Would you like to do it? And it's for her to say yes or no. Where the lines will start getting blurred is if the IC starts going to the respondent and saying, do you want to conciliate? Right? Because that's again often a party in a superior bargaining power position. You don't, then want to make it seem like he's pushing for a conciliation, and then the complainant feels like she is obliged to conciliate. So there is a line between pushing for conciliation versus giving the option of conciliation, and I think the IC has both the right and obligation to provide the complainant with that option if she's not already aware.
So, again, practically what happens is, one, the IC itself very often has not perhaps investigated enough, individual members, right, have not investigated enough complaints to understand the nuance and stuff. And the second thing that for me is a gray area is the IC itself influencing the woman to go for the conciliation because the IC believes that this is not an important enough matter, or this is not worth, and I'm putting the word in quotes, it's not worth wasting the people's time to, initiate a formal investigation. So I think that's really the fine balancing act for the IC, where, it is the aggrieved woman's choice. And yes, I mean, if there is an option, then information about the option to be shared. The other thing from an IC's perspective, and this goes back to a couple of cases that I've sat on, where it's almost like an out-of-court settlement, where a complaint comes in, the IC forwards it to the respondent, and then something magically, mysteriously happens, and then a few days later, both of them come back, the aggrieved woman and the alleged perpetrator, and say, hey, we've talked about it, and we realized blah, blah, blah kind of thing, and we've agreed to settle the matter. Sometimes, and I'd like to hear your views about this. The woman even says, I'd like to withdraw the complaint. And at other times, there's like, no, we'll just go in for a conciliation. We don't want an investigation. What are your thoughts around that?
Yeah, I mean, Laxmi, I can imagine this happening fairly often, right? And from what you're saying, it sounds like it does happen. The IC does have the right here to involve itself in the conciliation proceeding, right? The duty of the IC is not to just hear the parties and record what they have, right? Like you said, and rubber stamp it and say that's the final report. That's not the role of the IC. Because there are legal guidelines around how a conciliation proceeding can be concluded. For example, that there can be no monetary settlement that forms the basis of it, right? And the conciliation itself is a voluntary matter. The IC needs to make sure that it is being conducted in a manner that is voluntary. So IC can involve itself to make sure that there is no monetary settlement, that it is voluntary. If it sees evidence of there being some kind of coercion, right, the IC can step in and have a sidebar with the complainant to make sure that she does want to continue this conciliation process, and tell her that she has no obligation to do it. And ultimately, she's an adult, so if she, despite these options being given to her, she chooses to continue with the conciliation, then so be it. But the IC has a duty to keep its eyes and ears wide open and to take steps to make sure that the conciliation process is run in the way that it should be.
Yeah. And I think that's, that tightrope walk that the IC needs to do, right?
Yeah.
To follow the act both in the letter and the spirit.
Correct.
And that's an interesting evolution. The third question that comes back, Bishen, again from a practical this thing, is we know there's a 90-day requirement, right, for the report to be generated by the IC. So everything has to be complete. So does the clock start when the complaint is received? So let's say complaint is received, aggrieved woman says, hey, I'd like to initiate settlement proceedings, conciliation proceedings. And during the conciliation proceedings, she changes her mind and says, no, actually, you know what? I want to go for a formal investigation. it could be day 30. So does it mean that I have only 60 days left?
Yeah, so that's a legitimate question. And not only would this be a case where the woman changes her mind, it could be a case of the conciliation having failed through the entire process and then the investigation having to be done. So, in both of those cases, the question is valid as to when does the 90-day period start and how long does one have to conciliate. And the reality is that there is no answer, as many of the questions that we discuss here are gray areas under the POSH Act, right? So, there aren't
Yeah.
always answers to these questions. But the conservative interpretation, the most compliant way of reading that 90-day period is to say that the IC must investigate and close a complaint within 90 days from the time the complaint is filed, right? If we
Yeah.
take that interpretation, then the conciliation needs to be completed within that 90-day period. So you cannot take 90 days to conciliate, because then you will have no time to investigate should the conciliation fail. So you would have to finish the conciliation in 10, 15, 20, 30 days so that you still have about 60 days to investigate. But you could argue that that forces the IC and the parties to complete the conciliation process in haste, and the intent of the act could never have been to speed up a process, possibly at the cost of justice. So you could then take another interpretation to say that the clock will start ticking only when the investigation actually starts. And I would imagine that if you are able to show good grounds for why the conciliation needed to take, say, 45 days, why it is reasonable to say the clock starts for the investigation after that and you can have 90 more days. So I think so what I've told you is, one, there is a conservative way of seeing it, but I think the second way of seeing it is fair in the interest of justice as well. And the court will see value in that argument as well. So there are definitely two arguments possible there.
Yeah. Yeah. And from the IC's perspective, it's like, oh my God, now that means that, I've got to block my dates for an additional, X number of days.
True.
So all in all, I think there's enough gray area in the whole kind of, section around conciliation that I sneakily kind of accept, or well, I sneakily suspect that these conversations have driven the choice that, let's just do away with conciliation. There doesn't seem to be, like, the upside of it is not enough, right?
Lakshmi, I just want to add one small point though. And maybe just to add that some of the recommendations, like we discussed that the ICs has a role to keep its eyes and ears open, right? Which also may extend to then making sure that the recommendations or the agreement between the parties there is practical. For example, the employer is not involved in the conciliation process, and that's the way it should be, because there could be an opportunity for undue influence. But the ultimate conciliation report, the agreement between the parties still has to be practical. For example, the parties should not be able to agree that we can both continue in employment here as long as the respondent is transferred to a different office, because the employer may not be commercially, from a business perspective, be able to transfer them. So the IC's keeping its eyes and ears open should possibly extend to making sure that the agreement between the parties is practicable, operational, feasible, etc. as well. So that's an extra obligation that we could maybe impose on the IC, though not strictly there under the law, to avoid situations where an employer is simply not able to implement the final conciliation report.
Yeah. And the more I hear about all of this, I think, again, from an IC's perspective, it's just that, oh gosh, now I've got to understand the business realities of my organization before I So let's do away with conciliation. Let's wait for the amendments to get passed, and then we'll deal with the act. As of now, we still have it, but let's see what happens in the future. Fantastic. As always, Bishen, thank you so much for your clarity and for really focusing us on what we need to be focused. And I'm looking forward to the next in our series of conversations for season 3 of the POSHpod. Thank you.
Thank you, Lakshmi, and bye everyone. Look forward to hearing from you in the comments, and see you in the next episode. Bye-bye.